Okay, counsel, you're up.
Good morning, Your Honor. I'd like to reserve 5 minutes of my time for rebuttal. My name is Andrew Fine, and I represent the appellant, Peter DeAndrea, as personal representative of the estate of Ann Sims. This case presents an issue to this court of which statute of limitations should apply to the appellant's action to enforce 2 promissory notes. And specifically, I would like this court to approach this case by specifying what law applies to what issues in the case. Because in preparing our brief and in our argument, it seems clear to me that where the appellate courts have gone astray on these types of cases are instances where the parties weren't careful about arguing which law applies to which issues. So because we are here in Florida, we, of course, must start with Florida law. And Florida law very clearly says that a cause of action on a demand promissory note does not accrue until demand is made. That's 95.0311. There's no dispute that in this case, the first written demand wasn't made until 2019, and therefore our suit was filed well within the statute of limitations, which is 5 years. Florida statutes of limitations are procedural in nature, and Florida will always apply its own statute of limitations to its own cases. That has been the law for many years. That's how the law was stated in Calhoun versus Greyhound, which was a Florida Supreme Court case in 1972, where the court said that statute of limitations are traditionally procedural and the law of the forum will apply.
But Mr. Fine, if I may, then after that, as Apolli, pointed out, didn't the Supreme Court kind of ventured away and Lumbermen's, didn't they say, and I quote, recognize a trend away from calling statute of limitations procedural and provided that the issue of which statute of limitation applies should be determined like any other choice of law issue. And if you follow Lumbermen, and Lumbermen, if you look at the facts of that case, they basically concluded that the Massachusetts statute of limitation applied because, and then they go through the language that pursuant to Florida's borrowing statutes, you need to look at Massachusetts law in order to determine the applicable limitation period. And so, and this language and all of this, it boils down to the legal term of, okay, lex loci contractus. And if you follow that, doesn't that go contrary to your argument that the trial court appropriately came to the conclusion that New Jersey law applied because that's where this issue, the contract was entered, and that was the place that ought to be, the statute of limitation ought to be governed. Give me an opportunity to respond to that, Mr. Fine.
Thank you, Your Honor. No, Your Honor, I don't believe that the trial court relied on that correctly, and I don't believe that's what Lumbermen's stands for. So if you read Lumbermen's was a September 1988 case. It was resolving conflict with Storiano, and Lumbermen's was specifically limited to contracts of auto insurance. And I want to quote to you because it's very important, because not following this specific language of the opinions is where the court, I believe, went astray below, and other appellate courts have gone astray. The court in Lumbermen's said, accordingly, the lex loci contractus rule determines the choice of law for interpretation of provisions of uninsured motorist clauses in automobile insurance policies, just as it applies to other issues of automobile insurance. Now, they were resolving conflict with Storiano, that the Supreme Court had decided just a few months prior to that. And if you look at Sturiano, which is 523 Southern 2nd, 1126, the court there specifically limited that case to automobile insurance contracts. And it says that at the bottom of page 11, on page 1128 of the opinion, it says, we answer the certified question in the affirmative, limiting this answer to contracts for automobile insurance, and approve the decision of the district court. And in fact, the court was so concerned about limiting it, they said it again at the end of the opinion on page 1130. For these reasons, we answer the certified question in the affirmative, limiting that answer to situations involving automobile insurance policies. So
how about Mr. Fine then, if you jump up to Lanui versus Risk, that dealt with a promissory note. And that case, wasn't there a suit to enforce a promissory note? And that's when the third DCA basically said that for causes of action arising in contract, which is our case here, that Florida adheres to the doctrine of lex, whether it's called loci or loci contractus. So that case dealt with a promissory note.
It did, Your Honor, but I would respectfully say that that case was, one, wrongly decided, two, is not binding on this court. And you can see how it was wrongly decided because they cite to Lumbermans as the support for that. But Lumbermans was not at all a promissory note case. So to cite to Lumbermans in a promissory note case is incorrect, and more importantly, ignored other precedent of the Florida Supreme Court, the Schatz case, which we'll talk about in a second, and even the Brown case from 1920, which was cited in Strauss v. Sillen, which both say that in a promissory note case where you have a note that's executed outside the state of Florida, but a suit brought in the state of Florida, that Florida law applies. The Florida statute of limitation applies. So again, this is why it's very important to specify which law are we talking about? Are we talking about substantive law, or are we talking about procedural law? Because even opposing counsel agrees that some Florida law applies here. They want to apply the Florida law of lex loci contractus, all right? But it simply doesn't apply here because statute of limitations are procedural in nature. And that was exactly this court's holding in Strauss v. Sillen, which is exactly on point, decided in 1981 and remains good law. There was
and I appreciate Mr. Fine, but then if Florida law, but doesn't Florida, if you look at Florida law, don't we have the Florida the borrowing statute, 9510, 95.10, that basically says that when a cause of action arose in another state, which it happened here, it says that it's let me quote it exactly, and its laws forbids the maintenance of the action because of the lapse of time, no action shall be maintained in this state.
But I have two responses to that. First of all, the law of Florida, and that comes from our own statute of limitations, 95.031, says that the cause of action accrues upon demand. So the cause of action didn't accrue in New Jersey under Florida law, it accrued in Florida under Florida law. But more importantly, when you go and look to New Jersey law sends this right back to Florida under the New Jersey statute that we cited in our brief, which is 22, New Jersey statutes 2A 14-26.2. That specifically says that if the statute of limitations of a different jurisdiction applies, then the statute of limitations of New Jersey doesn't apply. And very clearly, the statute of limitations of Florida applies here because you're using the borrowing statute to get to New Jersey, and the borrowing statute is part of our statute of limitations. So New Jersey law is sending it right back. Now, the trial court in entering his order, distinguished that statute by simply saying, well, that statute wasn't in effect in New Jersey until the late 90s, and these causes of action had already expired by then. So the court dismissed that statute and didn't apply it for that reason. But that wasn't the correct analysis, and the trial court didn't have the benefit of really having that point argued below, because it wasn't argued at the hearing below. But if you looked back at New Jersey case law prior to that statute, in the case of Jackie versus Benjamin, which was a 1910 case, New Jersey law said statutes of limitations are remedial, and therefore they are procedural, and therefore the law of the forum applies. And in fact, in Jackie versus Benjamin, it was similar facts to this case. There was a promissory note signed in Connecticut, sued upon in New Jersey, and the court said, we're going to apply our New Jersey statute here. It didn't apply Connecticut statute, it applied the New Jersey statute. Similarly, that is exactly what this court did in Strauss. There was a note signed in Georgia, due and payable in Georgia, sued upon in Florida, and this court properly said that the statute of limitations is procedural, and that Florida law, the forum statute of limitations, would apply. And none of that has been changed by any subsequent law. The cases that Your Honor alludes to that talk about getting away from lex loci and are also say that we should look to the significant relationships test when deciding where a cause of action has accrued. But that really isn't the law yet in Florida, although there may be a trend there. That isn't the law. The Supreme Court in Shapps accurately stated the law when they did their analysis there in footnote 3 in that case, which said that under lex loci contractus, the law of the jurisdiction where the contract was executed governs substantive issues regarding the contract, substantive issues, all right? But then they went on to say that Florida conflicts of laws jurisprudence directs that procedural issues are controlled by the law of the forum, which is Florida in this case. And that case, Shapps, was decided in 2002, long after Lumberman's. So if Lumberman's stands for the proposition that statute of limitations is subject to lex loci, that this footnote contradicts it. But Lumberman's doesn't, but the reason this footnote doesn't contradict it is because Lumberman's doesn't stand for that. Lumberman's was just limited to auto contracts, which provide a odd intersection of tort law and contract law.
So, Mr. Fine, if we follow your approach, that means we'll have to certify conflict then with Lanui versus Risk.
Well, yes, perhaps, Your Honors. I don't think you have to, because I think Lanui was also distinguishable in that in Lanui, there were agreements that had choice of law provisions in them that were ambiguously written to reference Ontario law and the state of Miami law. And the court said both of those apply, and they're in contrast. And then in one short paragraph said, well, we're going to use as kind of the tiebreaker here, lex loci, and lex loci says the law where it was signed. I think that case can be distinguished because there were bilateral contracts involved there. There was a security agreement signed by both parties. And I think that's an important distinction here, because here we have a promissory note that is only signed by one party. It's only signed by the maker, and it's a negotiable instrument. And it's certainly a special kind of contract. And so to apply all of the law that applies to lex loci simply to promissory notes is a little bit of trying to fit a square peg into a round hole. It just doesn't work correctly. But yes, you could. This court is not bound to follow Lanui from the 3rd District, and if the court wanted to certify conflict, it could certify conflict. But
Mr. Fine, you are at your rebuttal time, so proceed as you wish.
Okay, thank you, Your Honors. So I think the Schaps case makes it very clear that the Strauss case is still good law in the 2nd District, which, regardless of what you think of the Lanui case from the 3rd District, this panel has to follow good law in Strauss. It's binding opinion from the 2nd District. It hasn't been overruled, and were this panel not to follow it, I believe it would create intra-district conflict and lead to a grounds for an en banc rehearing. I'll reserve the rest of my time. Thank you, Your Honors.
I was going to do this. Okay, Ms. Jamo, you're up.
Good morning, Your Honors. Can you hear me okay? Perfect. Thank you very much. May it please the court. My name is Caitlin Jamo, and I represent Frederick R. Newell, who respectfully requests that this court affirm the lower court's grant of summary judgment. I want to start by saying our primary position here today, looking at this globally, is that these 2 or 3 different standards or processes for looking at what law applies can all work together. While our position is that lex loci contractus is the appropriate standard to be applied to these facts, our position primarily is that none of the cases that are relied upon in either of the parties' briefs or here today in oral argument were improperly decided or can't work together in some fashion. Now, there certainly is a gray area in terms of whether there's overlap between lex loci contractus, significant relationship test, or even the current extent of the existence of the substance versus procedural analysis. But based upon all of the cases here today, and frankly, I'll even rely heavily upon the Schaps footnote 3 of the Schaps decision, we can see that all of these standards, particularly the significant relationships test and the lex loci contractus test, can all work in tandem. We do think here today that the court, first and foremost, appropriately relied upon lex loci contractus in determining that New Jersey law applied. Now, I want to take a second to clarify and highlight that, yes, this is a statute of limitations issue, because statute of limitations is the vehicle by which the trial court rightly found that the 1984 and the 1986 promissory notes were barred by the statute of limitations. But there's 2 questions, and really the dispositive issue between New Jersey and Florida law is that of accrual. Because under Florida law, as stated by appellant, the cause of action for a breach of note did not accrue until 2019, more than 30 years later, when there was a demand, whereas in New Jersey, it accrued upon the execution and delivery of the notes at issue. So even if we're looking at this as a substantive versus a procedural issue, we're looking at a major part of what the rights and the obligations of the parties are in terms of whether or not Mr. and Mrs. Sims, the original individuals who loaned, were required to do anything in order to enforce their rights and their obligations under the notes here in order to have a cause of action and preserve a cause of action for breach of note. So because we're looking at this, then the doctrine of lex loci contractus becomes appropriately applied. That doctrine, as explained in Lanui, in the Lumberman's case, in the cases that we already discussed here today, stands for the proposition that when you're looking at and interpreting a contract provision or the rights and the obligations of the parties, the law of the state where the contract was entered into is the law that should be applied. Here, because it's New Jersey, at the time that the note was executed and then delivered to Mr. and Mrs. Sims, at that point, the cause of action accrued in 1984 and 1986, and by 1992, under New Jersey statute of limitations, then at that point, the cause of action and ability to enforce these notes no longer existed. Lex loci contractus makes sense, and the policy as articulated in the Suriano decision is that parties should not be able to move in order to change what law governs their relationships, their rights, their obligations, and what the interpretation of the provisions or what their obligations are. Now, appellant tries to distinguish lumbermen's and narrow lumbermen specifically to the context of insurance, which I agree that the language cited does specifically refer to insurance policies. But as Your Honor pointed out, Lanui stands for the proposition, even if you have distinguishing facts in there, that lex loci contractus should be applied in the context of a promissory note. I'll also rely upon footnote 3 in the Schaps decision, where the court did not specify that lex loci contractus should be applied only to insurance contracts, but used more general language that lex loci contractus applies to contracts.
I pulled the footnote because I wanted just to reread it. And the footnote in Schaps, which Mr. Fine wants us to, saying that it governs our position, it says under Florida conflicts of law rules, the doctrine of lex loci contractus directs that in the absence of a contractual provision specifying governing law, a contract other than one for performance of services is governed by the law of the state in which the contract is made. And in our case, we didn't have a contractual provision specifying the governing law. So the Schaps case really doesn't contradict what Lanui says. It basically supports, or at least they both are consistent. Let me put it this way.
Absolutely.
Because I was troubled with what Mr. Fine was suggesting, that perhaps if we come to a different conclusion as Lanui, that somehow we are running in conflict with Schaps. But in looking at the footnote, and the Schaps case dealt with an insurance issue, did it not? Okay.
Yes, Your Honor.
I'm sorry. Go ahead, Mijum.
No, Your Honor, and I absolutely agree. Footnote 3 in Schaps is of particular importance, and we agree Schaps, it certainly is the law, and we have no challenge to the law that was articulated in Schaps, and don't even try to narrow it. In fact, footnote 3 goes on to also cite the Strauss decision, which is relied upon by appellant in this procedural versus substantive analysis. Now, subsequent cases such as the Bates decision, Bates versus Cook from 1987, starts to talk in terms of a trend away from procedural versus substantive, but I'll acknowledge that there are more recent decisions where you still see substantive versus procedural analysis. And that's where the gray area I articulated at the front end comes into play, because there is a little bit of these three standards floating out into the ether and figuring out when they should or should not apply. But footnote 3 of Schaps is of particular importance because it shows that lex loci contractus, and whether it's a significant relationship test or specifically the substantive versus procedural test articulated in Strauss, that they are both the law, they are not contradictory. And our position remains that they are both the law and they are not contradictory. But rather, when a court is interpreting the terms of a contract, or a court is determining the rights and the obligations of a party in a contract situation, that lex loci contractus is the appropriate standard to articulate. And that applies specifically to the Lanui decision, to notes, as we can see in the Lanui decision. This court does not have to overrule or certify conflict with any other decision from any sister court or of the Florida Supreme Court in ruling in favor of appellee here today. All of these standards can apply and can work together. One thing I want to highlight as well, just because it was raised in oral argument, is to clarify from the New Jersey law standpoint the interplay between what almost appears to be two competing borrowing statutes, where New Jersey law says that you can look to Florida law, and Florida law says where the cause of action arose, you should look to New Jersey law, at least in this specific instance. if the court determines it arose under New Jersey law. And one thing I first want to highlight is that under the cited section, which is 2A 14-26.2, it wasn't adopted until after the statute of limitations had already run in New Jersey. And as we cited in our answer brief, Sarasota Coolidge versus Rotondi, a New Jersey Superior Court decision, that it's inappropriate to then rely upon that specific section, which was adopted after the demand notes had already been created. So in terms of what is the appropriate law is looking at 12A 3-122, which was in effect in 1984 and in 1986, and frankly, all the way through the extinguishing of these claims at the time, which created the accrual was as of the date that the notes were entered into in 1984 and 1986, and that they subsequently extinguished 6 years later in 1990 and 1992 when the 6 years period of time had lapsed. Now, Your Honor, while we do maintain that Lex Loci is the appropriate standard and full stop, that could be the end of the court's analysis. To the extent that the court does want to engage in a significant relationship test or even under the substantive procedural test, we would point to the fact that the only relationship between the parties here in Florida is that Mr. and Mrs. Sims, at the time the notes were executed, resided in Florida. But the drafting of the notes, the execution of the notes, the delivery of the notes, the conversation surrounding the notes all occurred within New Jersey. So if the court is inclined to engage in a significant relationships test, our position would be it would still be appropriate to apply New Jersey law, just because the significant relationship at the time that these notes were entered into by between all of the parties, Mr. and Mrs. Sims and Mr. and Mr. Arnul, occurred within New Jersey, and we would rely upon our record sites and our affidavit in opposition or in support of the motion to dismiss, which was incorporated into the motion for summary judgment at 247 to 248. So, Your Honors, with this, I'm happy to go through a further analysis in terms of the significant relationship test, but really, at the end of the day, because this is a promissory note and because of the language included in Lanui, as well as, frankly, even within the Schaps decision, it's appropriate to apply the Lex Loci Contractus, which is clearly that of New Jersey. And with that, Your Honor, I don't have any additional substance that I would bring forth. We've included a number of other arguments within our answer brief, but just based upon the arguments raised in oral argument for appellant today, that seems appropriate. But I'm happy to answer any additional questions.
I have no questions.
Thank you very much.
Thank you, Ms. Jamo. Mr. Fine, you're up for rebuttal.
Thank you, Your Honor. So I want to, again, address Judge Kuzam's question about footnote 3 in Schaps, because I submit it's not appropriate to simply read that first sentence of footnote 3 and conclude that the New Jersey statute of limitations should apply. Because, and it's important to look at what was going on in Schaps, all right? So in Schaps, there was an insurance contract that was utilizing Lex Loci and applying New York law. It was applying New York substantive law, but the court nevertheless ruled that the Florida burden of proof would apply, not the New York burden of proof, and that burden of proof would apply because burden of proof is procedural. So that footnote, and that's why in the footnote, while they state the general law initially, they then break out substantive versus procedural, which again is what the court needs to focus on. All right, the substantive issues here, even if this court finds that this was a New Jersey contract, the substantive law would be New Jersey, usury, etc. But they go on to say in the footnote 3, Florida conflicts of law jurisprudence directs that procedural issues are controlled by the law of the forum, and statute of limitations is clearly procedural. as said by this court in Houck versus New River in 2005, which I would point out, Judge Casanueva was on the panel.
And if I may, Mr. Fine, because I know you're only on rebuttal, I want you to give it the opportunity to respond to Ms. Jamos about the significant relationship that if we go there, that you said even applying that still New Jersey would apply. I want you to have the opportunity before you're cut off to address that.
Sure, Your Honor, thank you. So clearly the significant relationship test would be applied here and in all directions points to Florida. This loan was made by Florida residents, all right? There was no place of payment specified. So under Florida law, payment was due where the creditor resides. That's Florida. We now have a Florida estate suing to enforce that obligation against a Florida resident. So the only thing that happened in New Jersey was that these notes were signed in New Jersey. Everything else about this case, the lenders and where the payment was due, was all Florida. So we would be happy for this court to apply the significant relationship test here, because we believe that can only lead to one conclusion, which is that Florida has all the significant relationships here, save the fortuity of where the note was signed. And to rely on that fact in today's age of digital signatures and DocuSign, as opposed to looking to where the lender resides, makes it very clear that Florida has the most significant relationship here. So in ruling, I want the court to recognize that either this court's going to have to make a ruling that's in conflict with Lanui from the 3rd District, or is in conflict with Strauss v. Sillen, which is this court's own decision, exactly on point factually, cited with approval by the Supreme Court in Shapps, also cited subsequently in an additional time in Hertz versus Piccolo, and is still good law. So if this panel doesn't reverse on the grounds of Strauss, then it's going to be in conflict with Strauss. And for those reasons, we think that the court should reverse. In fact, I'll just close by quoting Strauss, which was relying on a case called Brown versus Case from 1920. And it said, Strauss submits that the trial court should have followed Brown v. Case. We agree. I make the same argument here. We submit that this court should follow the Strauss v. Sillen and reverse, because the case is directly on point and binding precedent. Thank you, Your Honors.
Thank you, Mr. Fine. Thank you both very much. In order to leave our virtual courtroom, you need to click the button called Leave on your Zoom screen, and you will